Well, good evening, everybody, and welcome to our In Conversation, CPD, to discuss contemporary issues in civil and criminal contempt. Before I get going and introduce our guest speaker this evening, I have to apologise on behalf of Dawood Subtain, Senior Counsel, who unfortunately is not here tonight. And so he would ordinarily do the welcome to country, and therefore it falls on me to give the welcome to country. So before we get going, I would like to begin by acknowledging and paying my respects to the Gadigal people of the Aurora Nation, the traditional custodians of the land on which we are conducting the CPD. I would like to pay my respects to their elders past, present and emerging, and acknowledge all Aboriginal and Torres Strait Islanders participating today, also paying my respects to your elders past, present and emerging. Well, given how quickly this CPD has sold out and how quick some of you were to send us some rather curiously tailored questions, David will be known to all of you in the room and also online. But one stage, we at Level 22 Chambers thought that we would call this the 2024 first meeting of the official David Rolph fan club. But for the minority in the room and watching online, David is, of course, the professor at Sydney University Law School specialising in media law. He is the co-author of the 13th edition of Gatley on Libel and Slander and the 7th edition of Cases on Torts. And for many years, he was the editor of the Sydney Law Review. And of course, as everyone here knows, is the publisher of innumerable journal publications. Most recently, of course, David has published his book on contempt, which I'm now going to shamelessly plug on his behalf. Available at all good bookstores and in particular through our clerk Jackie, who sits in front of you for those in the room. This was published 5 months ago, shockingly, although to call it a book does it, I think, a disservice. It might be more accurate to describe the book as a tome because, of course, as we all know, those of us who have bought it, as the first Australian text dedicated to the subject of contempt law, it comprises a very cool 831 pages. In the foreword of the book, Chief Justice Gageler described it as long overdue and extremely welcome. At its official launch in the New South Wales Supreme Court, Chief Justice Bell of the New South Wales Supreme Court was so clearly delighted that David had published a book concerning such a complex and diverse subject that His Honour didn't want to be constrained in describing it. David's book was described by His Honour as a magnum opus or a tour de force and even at one stage magisterial. At its launch in Western Australia, the former Chief Justice French said this: David Rolph's work is a major piece of Australian legal scholarship and will be a reference book for students, practitioners and judges for many years to come. And later, His Honour endorsed David's own held belief that he has had the courage to forge a path through the legal thicket where many others would fear to tread. And not to be outdone, His Honour Justice Lee, formerly of these chambers, of course, offered his high praise, at least in His Honour's own inimicable way, in a small case, you might have heard of it, called Lehman and Network 10, when His Honour said this: the role of the law of contempt in this area is, with respect, usefully explained by Professor David Rolph, and so forth. Now, indeed, at least to our count here in Chambers, and allowing for the January break, where, of course, everyone realises that no one's around in court, David's published work has, so far, been cited at least once a month by the Federal Court, the New South Wales Supreme Court, and the ACT Supreme Court. And at the time when he should be no doubt putting on his slippers, kicking back and enjoying his beloved Murder, She Wrote, we are very honoured this evening that he has chosen not to take that path and to be in front of you all this evening to address some questions on contempt. Now, just before we get going, some housekeeping. This seminar we anticipate will last for about an hour. We will take questions at the end, so please don't rush to ask questions of the good professor. And any questions from those watching online, please do send them to our clerk Jackie on email, or alternatively, you can feel free to comment on the YouTube channel, which is being monitored. So with that being done, and with all the introductory remarks out the way, David.
Yes.
Spent 5 years on this book.
Yes.
Extensive research. In your view, what is the current is the current law on contempt satisfactory in your view, and if not, why not?
Well, I think the short answer to that question is, given that to describe the law of contempt in Australia takes 831 pages, it's not in a very satisfactory state. It's not terribly sort of accessible. And I think that that's a real problem, because the context in which practitioners and judges need to deal with contempt are usually in sort of urgent situations. So issues of contempt will ordinarily arise in acute circumstances, particularly contempt in the face of the court. And to have a body of law that most people don't have to interact with except from time to time, usually on an urgent basis, the fact that the law is so vast and so complex, I think, is actually a real problem. And it's compounded because it's a summary jurisdiction, so it's rarely the subject of appeals. And the inaccessibility of it, I think, raises real problems about potentially inconsistent approaches to the application of the law. And I think that that's obviously then a problem for justice, because it then becomes really a sort of luck of the draw as to the arguments that are put, or the judicial officer and their disposition to the particular type of contempt in issue. So I do think the complexity of it is a problem. During the writing of the book, I sort of went on a journey actually about, my view on this, because I'd started off thinking, well, typical sort of academic lawyer, the common law, it's a nice intellectual problem, it's nice and difficult and complex, and I'm going to sort of master this. By the end of it, it became clear to me that it's sort of, irrational for that to be the case. And actually, there's a real benefit to following the course of places like the United Kingdom, which has put substantial amounts of contempt of court on a statutory footing, or somewhere like New Zealand, which more recently has put basically the whole of contempt of court on a statutory footing. And that's also been the recommendation of the Victorian Law Reform Commission. And I think the benefit of that is, if there is a standalone Contempt of Court Act, that practitioners and judges know that that's where you find the source of law, sort of rationally explained. That makes it much easier. I don't want to dissuade anyone from buying a copy of the book, obviously, but it seems to be a much more satisfactory, rational approach to what is a really vitally important area. It's fundamental to the administration of justice.
So does that mean that we're back to the 2003 recommendation of the New South Wales Law Reform Commission, which said we should have a statutory basis for contempt law?
Yeah, I mean, you can't codify it. You can't completely oust, the residual inherent jurisdiction of the court, but you can substantially regulate it. And I just think that, to my mind, makes sense, because, it is vitally important to the administration of justice. So you do actually want practitioners and judges readily to be able to identify the source of law.
And given the appetite of the judiciary so far for your book, it would seem that they would also share that view. But why do you think that so far we haven't had legislation in Australia dealing with this?
Well, I mean, Australia's had a sort of interesting sort of history of not translating Law Reform Commission recommendations into actual law reform. So, I mean, one of the things that I point out in the book is, and anyone who sort of looked at the 1987 Australian Law Reform Commission inquiry into contempt will be struck by that. I understand that Michael Chesterman was the sort of major person responsible for that. That's a huge work of scholarship and makes, a significant number of, very sound recommendations. And when you look at the number of recommendations that were actually implemented, I think from memory, there were a few amendments to the Family Law Act to rationalise the family court's jurisdiction in relation to contempt. But most of the very rational sort of recommendations were completely overlooked. I mean, one of the things that I found particularly sort of challenging in writing the book is I go through the procedure of the High Court, the Federal Court, and all the sort of superior courts around the country, and the sheer diversity of procedural sort of approaches to contempt, the sheer variety of that is a really significant problem. You sort of just go, well, we know basically what the forms of contempt are. There would be a rationality to trying to deal with those in relatively sort of consistent ways, and that would just make life easier for practitioners, judges, but also for litigants, for people who are actually affected by contempt of court.
I think every judge so far that's commented on your book has commented as to how complex and how sort of what a morass of information is out there on contempt. And it's, as practitioners in the room and online, it's always difficult to traverse those issues, let alone for a litigant in person who has no idea what the procedural rules are and where to find them. And it does strike me as strange that there's no practice note, for example, on contempt, let alone legislation about it. But what do you see as the sort of the pressing issues in contempt at the moment from a general perspective?
Well, I mean, the obvious one from someone who's sort of interested in media law is, sub judice contempt and how sub judice contempt is or is not, sort of the principles of sub judice contempt are or are not respected. And, you wonder the extent to which there's a sort of consciousness of the requirements of sub judice contempt. I mean, obviously something like defamation is something that media practitioners are much more exposed to sort of regularly. I suppose sub judice contempt is something that has a particular application to the reporting of criminal matters. But reporting of criminal matters occurs, with a fair degree of frequency. And it's interesting in high profile sort of, matters. I certainly do collect a bit of teaching materials along the way. It strikes me that sub judice contempt is a difficult area because those principles are supposed to be self-executing, and practitioners and media and legal practitioners are supposed to respect them and comply with them, and to avoid the hard law of a suppression order. And I do suspect that actually, and someone like Jason Bosland has sort of made this point on a number of occasions, that the incidence of suppression orders is connected to a concern on the part of the judiciary that you can't rely on people to comply with sub judice contempt. And so suppression orders are sort of put in there as hard law to sort of secure compliance with what should be complied with in any event.
Yeah, and I suppose in terms of a teachable moment to some lower courts anyway, that some of them don't realise what sub judice is, and so they assume that someone's not going to adhere to suppression orders, when in actual fact they didn't realise what sub judice contempt
What do we need to
is. And I think sort of this obviously went very well in rehearsal. One magistrate actually said to me relatively recently, and this was at the end of last year, in a case where I appeared for the media and under suppression, where I was giving this exact submission where sub judice has work to do, and you've got to give it its work to do. And the magistrate said to me, "What, sub judice contempt? Like, you might need to explain that." And that could be the problem. So on that topic, for everyone online and those in the room who don't know, looking around, I think everyone probably has a very good idea as to what it is. But what is the basics of sub judice contempt?
Well, so, I mean, sub judice contempt is a form of contempt which is directed to protecting against interferences with the administration of justice in a particular proceeding. It applies to all forms of proceedings, civil and criminal, but it has its most acute work to do for a criminal proceeding that's going to be heard by a jury. So sub judice essentially means, before the court. So when a matter is before the court, there are restrictions then on what can lawfully be published. And so under Australian law, a criminal matter is sub judice from the time of arrest. Position is slightly different, or maybe slightly different in the United Kingdom. But as, Chief Justice Griffith in Packer and Peacock makes clear, the New South Wales Court of Appeal in 1990 and Attorney General and Channel 9 reaffirmed, once someone's arrested with, even if they're not eventually charged, it's arrest which initiates the criminal process. And from that particular point in time, there are then restrictions on what can be published. So basically from that particular point in time, the two sort of lawfully, the lawful categories of what you can publish, and these are the sort of major defences. You can publish a fair and accurate report of a court proceeding, but of course not everything in a sort of investigation or in a crime, reporting of a crime, will necessarily have a particular instance where there's something occurring in court. So the much more important one is the bare facts defence. So once someone has been arrested, from that point onwards, you can publish the bare facts of the investigation. That, of course, raises a somewhat neat question about what is a bare fact and what is a non-bare fact. And that, I think, can be a bit contentious.
To the media who might want to add a little bit of colour and movement, you mean in terms of
yes, well,
reporting of the bare fact?
Colour and movement does suggest that it's not a bare fact, almost by definition. I mean, Chief Justice Griffith in Packer and Peacock tries to define a sort of bare fact as an extrinsic ascertained fact and impliedly a non-contentious fact. So, you know, if someone has been violently killed, you know, then you can describe, you know, the fact that the person has been killed, that's a bare fact, the person has been killed in a violent way. And Justice Windier and James and Robinson suggest that you can even describe that as murder because the ordinary reasonable reader would understand a violent killing as a murder. That's a bare fact. If that's what's occurred, you can report that. That's not contemptuous.
That's distinct from an alleged murder.
Alleged murder, yes. It's like, yes, I think the allegation is not that the person has been violently killed. The allegation is to who is responsible for the violent killing, and that is not a bare fact until they've been convicted by a jury. I mean, all of this through the life of a post-arrest is concerned with ensuring that the person actually, when they face trial, and you have to deal with it prospectively from the time of publication, and you have to assume that the person is going to face trial. And for murder, that will be a trial by jury. All of the restrictions are directed towards ensuring that that person has a fair trial. And so publishing anything that would affect that person's right to a fair trial is something that carries with it a substantial risk of serious interference with the administration of justice, which is really, I think, the best articulation of the test for sub judice contempt.
So in terms of defences, look at sort of bare fact and fair and accurate reporting. What about the role of bread manufacturers in that context?
Well, so yes, so this comes back to the idea of, you know, it's not any risk, because obviously publishing something about a particular proceeding could carry with it a risk. And so it's never been the case that it's any risk. And so through a sort of series of cases, High Court and New South Wales Court of Appeal cases, you have various articulations of that, the real and definite tendency, or as a matter of practical reality, a real risk. The problem with all of those sort of formulations is I don't actually think that they're sort of sufficiently emphatic or adjectival. And so you have someone like Chief Justice Mason in Hinch's case, where he says, you know, it has to be a substantial risk of serious interference. So it's not any risk, it has to be a substantial one. And it's not any interference, it also has to be a serious one, which I think just reinforces the nature of the contempt jurisdiction, because it's a summary jurisdiction, it should be a jurisdiction of last resort. When it actually goes into motion, it can be quite severe in terms of its penalty because it's a strict liability regime. But, you know, we know from the case law that there are certain types of publications that carry with it, you know, very sort of significant risks. So the bread manufacturer's principle is really important, and there's no sort of, you know, balance that is, you know, predetermined. In every case, you have to make an assessment of the competing public interests against the risk to a right to a fair trial. But in many cases, you know, if you're advising someone, you can make a fairly good assessment about the way that a court will decide. So if you're going to report something that, you know, reflects adversely upon the guilt of, or suggests the guilt of the accused person in a particular case, then you're going to have a very compelling public interest to outweigh that. And there are very few cases, I think, where if you're going to the very issue that a jury would have to determine, the guilt or the innocence of the, you know, the accused person, there are very few cases where the public interest in public discussion is going to sort of overwhelm that.
What about in the circumstance where there's a continuation of public comment, as it were, in the media on a certain issue, which is, it's been published perhaps for quite some time, and sort of the impugned publication, for want of a better expression, is just continuing the public debate. Sometimes I think the bread manufacturer's principle would apply to that ordinarily, would it?
Yes, but I mean, in a way, I mean, bread manufacturers is a case about a sort of civil jury trial. So, not that there are particular sort of rules, but the way in which the balance would occur would be different. So, if you think about something like Hinch's case, Mr. Hinch was particularly sort of concerned about, child sexual abuse and the Catholic Church, protecting Father Glennon, and sort of, in a way which is sort of unbelievable today, allowing him to continue in various sort of children's charities and things like that, notwithstanding the charges being laid against him. There are obvious sort of public interests there, but the High Court was firmly of the view that to repeatedly sort of expose the previous convictions and allegations, charges against Father Glennon, at a time when he was facing still further charges, that even though that would constrain that sort of public discussion, that was the way in which the balance between those competing interests had to operate. So sort of it really depends on the case. I mean, I suppose an instance where the sort of public interest argument sort of prevailed were cases sort of in the mid-1980s, where you either have sort of marginal reference to someone's, conduct, or you have a sort of, Attorney General on Fairfax and Bacon, where you have a sort of long-form journalistic piece about police corruption and allegations about police corruption. And in the context of that, you suggest that the late Roger Rogerson might not necessarily be the nicest person.
Which we can say now because he's deceased.
Yes, of course. You can defame the dead, and I take no comfort from that. As a good friend of mine once said. But in that sort of context, where you have a sort of broader sort of public interest sort of piece, larger sort of investigative journalism piece, and as a part of that, you then suggest that the person is, disreputable, then that is something that was an instance where the New South Wales Court of Appeal was willing to actually say public interest concerns prevailed. So, I mean, really as a sort of guiding principle, because that was a case which was essentially disparaging the character of an accused person, that's a sort of category where public interest considerations might balance against it. It's a much more where what you're suggesting reflects adversely on the guilt or the innocence of the person in a criminal trial, where that's much more difficult to make an argument that public interest allegations are going to prevail, because that's the central issue for the jury to determine. So every case has to be determined on its own particular facts, but we can start to make some sort of assessment about the sorts of things that are much more likely to be a problem.
So is there any limit to the principle of sub judice?
Well, I mean, you do have the balancing. So, I mean, and there will come a time where the matter is no longer before the court, and at that particular point in time, or, particularly after the person has been, after there's a resolution of the trial, then of course the role of contempt is that discussion of what occurs in courts is given over to the public to make their assessment about what occurs. I mean, there are limits in the sense that you can discuss, what has been said in court, so that can be fairly accurately reported. You do have, bare facts. You do have those sort of countervailing considerations for public interest. But a lot of this is just constraints on speech during a particular point in time.
So it's almost like a delayed publication point.
Yeah.
In terms of recent examples, there are a couple that spring to mind.
Oh, yeah.
Might be something relatively recently, even to some of the in-house lawyers and media organisations in the room and online. They'll know what I'm talking about. But what's your view of this, David? this,
Sorry.
this reporting
I
that's
love,
been
I
happening.
love that I get this. What do you think of it? That's good.
Well, sometimes I'm called upon, and I have done recently, where I've had to give
Yeah.
pre-publication advice in relation to these murder charges from Bolamar Condon faces. And one thing that strikes me from the things that I've seen anyway, that I've had to give advice on, and that I've seen other reporting, obviously, and looking at news in particular. It is. I'm obviously joking, but when I've been looking at the articles that I've had to legal, some of it strikes me as the bare facts defence might be sort of lost in some instances,
Yes.
but in actual fact, I think it doesn't really add anything to the particular story that's being published, at least the ones I've seen, and it could be just tweaked ever so slightly so as to report the bare fact, and you don't lose the flavour of the actual article that you're trying to, or the information anyway that you're trying to get out there. I know that other organisations might take a different view, but what's your view on the Condon murder and the investigation, without naming any individual?
No. We won't descend to particulars. We might just put everyone off site.
This is dangerous territory.
Yeah.
For those online, you don't realise how much the atmosphere in the room can change very quickly at the moment.
Rhubarb, pitchfork. That's right. Look, I mean, the person in question was arrested at a very early stage, which should have changed the tenor of reporting quite markedly from a very early stage. And there have been a number of instances where I have been surprised that articles have been published, and I have collected a number of them for teaching purposes. There are some very interesting headlines that I've seen. The word alleged is used in a way which is wild. In circumstances where alleged allegation is not actually doing any real work, and I think a court would take the view that the inclusion of alleged in the context in which it's been published wouldn't do any work. I mean, it's not bare. There's a lot of non-bare facts reporting. There are a lot of contentious facts. Given that the story or the way in which the investigation has unfolded, and there's clearly a high public interest in this matter, and understandably so, but we are talking about a crime in which the person was arrested and charged at a very early stage. And I have been somewhat concerned about some of the reporting. I'm obviously, sub judice contempt requires prosecutorial discretion. It requires usually the Attorney General to prosecute, and we don't have, in the last sort of 15 or so years, really in this in fact, going in this jurisdiction going back longer, we haven't had sort of significant number of sub judice contempt prosecutions. The 1980s were really the sort of the decade in this jurisdiction where there were a large number of sub judice contempt prosecutions.
That might be about to change, looking at how popular your book is becoming with the judiciary.
Well, yes, I mean, of course, the judiciary could, the court can, of its own motion, sort of put in place, criminal contempt, of which sub judice contempt is a major form. But yes, I mean, I must say I've been surprised by some of the reporting. And so, I mean, in all of this, because the principles of sub judice contempt, operate by force of law, there's obviously been made an assessment about the risk that's involved in publication. And some of the reporting is more risky than others, I would think. And yes, I think there's a lot of contentious facts that have been published.
But how much, in terms of the decision to prosecute, how much is weighed into that sort of balance, though, with practical considerations such as likelihood of early plea, that sort of consideration, which would have a bearing on whether or not there would be a prosecution?
Oh, look, I mean, it's difficult to say because, again, because they haven't been regularly sort of prosecuted, I'm not sure that, the priorities of the people who might actually sort of want to do something about this have necessarily thought about those sorts of factors. So the Attorney General obviously has, standing to do that. The DPP may. If the matter gets before a court, then, there are real issues about whether a court would deal with that just by, using suppression orders rather than a prosecution for sub judice contempt. Because, of course, you'd then have to ordinarily delay the sub judice contempt prosecution until after the actual trial has occurred. So I'm not sure, because there hasn't been a sort of sustained sort of recent history of sub judice contempt prosecutions in New South Wales, whether there's actually a sort of well-developed sort of calculus of those sorts of factors. But you would imagine that those sorts of things would weigh into it.
Okay, well, and that sort of leads us, I suppose, on to the strict liability aspect of sub judice. Obviously, someone publishes a contemptuous publication, it's substantially going to interfere with the administration of justice. What about a situation where it's a republication? Would sort of similar considerations, for example, like I suppose the old Spate and Gosney sense of in defamation, is there something like that would apply for republication of a contemptuous publication?
Yes, I mean, in contempt and in defamation, Neville Wran has been very useful because, both of the cases involving Neville Wran have sort of been major sort of cases about extension of liability for republication. So, I mean, if you are republishing somebody else's material, then you're obviously publishing, so therefore you have to answer for what you yourself publish. But it's always open to a prosecutor in a contempt case to try and hold someone liable not only for their own statements, but for the statements that the extent of republication. So the Neville Wran case is the sort of the leading case on this, DPP and Wran. So he makes a statement directly to two journalists. It's overheard by a third, doesn't ask any questions, but then republishes that in the Daily Mirror, which I think at the time was the largest afternoon newspaper, with a very substantial circulation in hard copy that is simply not equalled today. And Rand's liability is not just for the effect that the statement has to the sort of two journalists, but obviously the natural and probable consequence of making those statements to three journalists is that they might in fact republish that. And so the republication, which is really what does the damage to the administration of justice, is something for which he can be held liable. And so liability for republication is something that you need to be aware of, particularly if you're a high-profile public figure or a public entity where you're disseminating information which is likely to be picked up and republished by the media.
Like the police, for example.
Yes.
Anyway, we go on to takedown orders in particular, because this is an area which, as you know,
it's very close to your heart.
It's very close to my heart. But in the area of takedown orders, sub judice has some work to do, and I always find, as I'm sure a lot of the people in the audience share my view with me, but I find that a lot of courts, certainly the lower courts anyway, tend to dismiss the sub judice elements of, and I was wondering, looking at your book, there's a pithy paragraph on Ibrahim, obviously, and John Fairfax and Ibrahim. But what was your view of or did you form a view on sort of how sub judice has a bearing on takedown orders in particular, or has some sort of relationship with the Court Suppression Act?
Well, I mean, you're in a better place than I am because this is really your bread and butter.
I haven't published a book.
No, I don't. You do it every day. You live it. I mean, it is that. I mean, it clearly should be taken into account because it's a body of law that exists which is supposed to inhibit, publication, and it's supposed to do that in a way that is sort of self-executing, and so you shouldn't need a sort of hard legal order to tell you what you can and can't publish if you've got a body of principle that is designed to securing that. Now, whether, and I mean, we were discussing this before, I mean, that's my reading of the judgment, that's your reading of the judgment in Ibrahim. But that's not a judgment that is, I think, shared by everybody, notwithstanding that I think Baston is clear about that.
Yeah, well, on that, I think he's clear enough, but it's quite a complex judgment in some parts, because I think I recently made a submission to another judge of the Supreme Court where it's almost like a jigsaw in some respects, because you've got to piece it all together. But it is quite frustrating, I think, that the law of sub judice clearly has a role to play when it comes to making, as His Honour says, peremptory orders directed to third parties not connected to the litigation. But I was wondering if you had a view of whether or not that's adequate protection, or is it? I think His Honour says makes the point that His Honour Justice Basson makes the point that it doesn't expand the law of sub judice contempt by virtue of the power of Section 7 in the Court Suppression and Publication Orders Act. Is that adequate protection for sub judice in those circumstances?
Well, I think the answer is probably no. But I mean, I think that gets back to the sort of the point Jason Bosland has made often, which is if you've got sort of a bit of hard law that you can deploy to secure a particular outcome, it's just easier to sort of do that rather than sort of sit back and sort of hope that people comply with a set of legal principles that you think they should in fact comply with. And the problem, and I mean, again, this is something that you're very familiar with and much more familiar with than I am, there's a real problem of allowing sort of these sorts of orders to be made, which again, need to be made, they tend to be on the fly. There aren't sort of, a lot of precedents or templates, so people often have to sort of come up with them on the fly, which is not ideal, and they have to be tailored to a particular case. But there's a real prospect that forms of orders, even though the legislation tells us that it has to be necessary in order to do it, and it has to do no more than is necessary in the form of the order, there's often, I think, a temptation or, it occurs that orders actually go further than is necessary and, do more than what sub judice contempt would require. And there are obviously review and appeal sort of mechanisms, but I do think it's problematic that forms of orders can be issued that go much further than sub judice contempt would ever require. Because, of course, how can you then satisfy yourself that it's in fact necessary to protect the administration of justice in those sort of circumstances? But I think that part of the problem there is that, the way in which these sorts of orders come about and the fact that we probably need to provide more guidance for practitioners and judges about, examples of precedents, templates and things like that, so that people are not having to sort of reinvent the wheel.
And practical matters, I suppose, as well, in terms of, for example, whether or not a publication is intended 3 months before a trial, or whether it's a week before a trial, or whether it's a year before a trial. In those circumstances, it can have a rather fatal effect on whether or not the publication should in fact be published.
Yeah.
One of the questions we've been asked, which we were going to come to later on, but I suppose it's actually quite an opportune time to come to it now, is the extent to which parties to litigation should correspond with the media about so-called contemptuous publications, at least that they consider to be contemptuous. And in the context of what we're talking about, Ibrahim in particular, His Honour Justice Basson makes the point much later in the judgment, where he says that it's a good idea for the DPP in particular to reach out to members of the media and identify certain publications that they want taken down, and then if the media say no, we're not going to do that, then there's an application might be brought in those circumstances and therefore be necessary within the meaning of the Act. And I think that was a point picked up by the Law Reform Commission recently as well in it was 2 years ago, I think it was, whether they double down on that point of view. But in terms of other examples, should they correspond with, this is obviously a criminal context that we're talking about now with Ibrahim, but what about sort of civil or in other kinds of cases? Should they correspond with the media? Is there an obligation to correspond with the media?
So, I mean, well, in the criminal context, you obviously have sort of, an emanation of the state. So that's, I mean, the civil context, I think, is probably different because that's, between parties to the proceedings. I mean, in the criminal context, I mean, just from a practical perspective, if you want compliance with suppression and non-publication orders, if you want compliance with takedown orders, then the people who are going to be most affected by them are media outlets. So it would be, I would have thought, and again, you'd have more practical experience of this, much more productive and much more fruitful to actually have that sort of discussion rather than, adopting a sort of more adversarial sort of tone to that. I would have thought, even if people take sort of markedly different views, if you think it's important enough to have a sort of suppression order made or a non-publication order made or a takedown order made, then engaging with the people who are the likely objects of that order would seem to be sort of sensible.
And there's the court liaison officer as well, the media liaison officer who'd ordinarily take that role and communicate on behalf of the court. And so ordinarily, you might not have to take that step, it seems to me, but in the criminal context anyway, the DPP is expressly told by the Court of Criminal Appeal to actually take that step if it's necessary. And it still sort of surprises me that usually when we go along for those sorts of applications, it hasn't been done. And then it's an obvious submission then, which is why this whole order is unnecessary. But moving on, because we're running out of time for taking questions. Another topic which I think is close to everyone's heart is the disobeying of court orders. So everyone obviously gets very frustrated with litigants in person, perhaps, or other litigants, being sophisticated litigants, not adhering to court orders. In what circumstances would contempt have a role to play in that situation?
Well, so disobedience of a court order is, civil contempt, so classic civil contempt. So, civil contempt is sort of, as with other forms of contempt, a last resort. So there are all sorts of other enforcement mechanisms that you've got and other ways and means of dealing with non-compliance before you get to civil contempt. So hopefully that should really be the last resort. So it's got to be willful disobedience rather than sort of casual or accidental or unintentional disobedience. But you need to have a sort of clear and unambiguous order. It has to be capable of being complied with, and the person who is the party to the proceeding has to be aware of or served with the order, and they then have to engage in conduct which is inconsistent with the order or undertaking or the injunction. And so they're the sort of basic requirements of a civil contempt. So it can only really be dealt with by another party to the proceedings who is aggrieved by the non-compliance. So it still has a role to play, and people are, prosecuted or punished for civil contempt. Civil contempt, I mean, the distinction between civil and criminal contempt is really sort of not a hugely important one, particularly when you get to sort of the penalties and relief that can result, because for civil or criminal contempt, you can be punished, you can be sent to jail, you can be fined. So there's no magic in sort of identifying something as a civil contempt in terms of the sort of consequences of that. But yes, I mean, you still get every year a handful of cases where people are sometimes actually sent to jail or subject to some sort of criminal sanction, often suspended. And, one would surmise that these are people who have not previously encountered sort of criminal penalties. So this is their first sort of, brush with this type of penalty.
We see former solicitors recently being sentenced in Victoria. There's been legal practitioners in New South Wales that have fallen foul of this as well relatively recently.
Yep.
And so it's a real risk, but we're not talking about triviality in this context. I mean, these are injunctions which have been breached. It's not sort of just a filed an affidavit late or by a week or something like that, just to be clear for everyone.
Yes, it's a jurisdiction of last resort.
Yes.
It would seem to be a sort of sledgehammer approach. A late affidavit.
Right.
You're going away for a week. Because how late your affidavit was.
But what about enforceability of those orders? Are there any sort of live issues in modern sort of contempt law that apply in this situation?
Well, I mean, the most interesting, I think, issue of enforceability is the extraterritorial aspect of enforcement, which is not necessarily as important in civil contempt, but criminal contempt. But I do think that that's a sort of live issue. So, the body of principle that we've got for contempt of court is very much founded on, the Superior Court of Record in the jurisdiction being able to protect the administration of justice in that jurisdiction, the Supreme Court of New South Wales protecting the administration of justice in New South Wales. And that sort of worked for, several centuries. But of course, now there's real potential for the administration of justice to be interfered with in a very substantial way from people who are located outside of the jurisdiction, but their conduct might have consequences within the jurisdiction. And I'm just not sure that, contempt of court is really adapted to deal with those sorts of challenges in terms of enforcement, because if the person is located outside of the jurisdiction, well, how is, the Supreme Court of New South Wales going to have jurisdiction over that person? How are you going to get them to sort of stop doing what they're doing? That can raise a whole sort of range of issues about jurisdiction and enforcement. So, I mean, I do think that that's a real problem. And allied to that, and, it's obviously a function of internet technologies, allied to that, and I talk about this at the end of the sub judice contempt chapter, I mean, one of the things that I'm sort of particularly concerned about is that the principles of sub judice contempt are really sort of founded upon this idea that there's a sort of single publication which carries with it a substantial risk of serious interference with the administration of justice, and that will then imperil a particular proceeding. And that's a very mass media 20th century sort of approach to that. I think the real problem that we now often see as a threat to the administration of justice is really the sort of swarm effect, where there are lots of private individuals prejudicially discussing a particular proceeding that's before the court. You'd be hard-pressed to find a particular person with a particular publication that has, carries with it a substantial risk of serious interference with the administration of justice. The problem is the cumulative effect of all that adverse discussion, creating a sort of adverse climate for someone facing trial. And the principles of sub judice contempt that we've received, I just don't think are really adapted for that particular type of threat to the administration of justice. And I think that that's a real threat.
I suppose, I mean, to the extent that you can't enforce an order internationally, I think you engage private international law principles in that situation, but it might bear on the necessity of an order for a suppression within the confines of the Commonwealth of Australia, potentially.
Potentially, yeah.
All right. Well, it's 25 minutes past. We've
talked a bit.
We've talked a bit, and I have a sneaking suspicion that those in the room and some people online, I'm told 5 questions are can be asked of you online. They all want. They're all champing at the bit. Now, form an orderly queue, please, ladies and gentlemen. First up, let's go to the floor. Like Gina, I can see you, so that you're agitating for us to ask a question.
I've got a working theory, and you can shoot it down. But an Apple version of contempt where it's a statement about a person's innocence rather than their guilt. And the primary issue is that it's made not only that's the statement, but that it's made by someone with very high social standing. I think the internet has killed that version of contempt, dead and dead. What do you say?
I mean, I think that there are many instances in which a statement of innocence would be, you know, not contemptuous. So, I mean, if a person themselves says, you know, consistent with the presumption of innocence, you know, or, you know, the spouse or parent, you know, expresses publicly that they believe the person to be innocent, and even if that's picked up and published, you know, widely, I think that you would be hard pressed in those sort of circumstances, because I think to have that as a sub judice contempt, because I think the argument could be made, well, of course that person would say that. So I do, I mean, particularly in the sentencing judgment, you really get the sense that they were not impressed with the fact that this was someone who was the Premier of New South Wales, who was a QC, who was known to be a very good friend of this person. You know, it's again incredibly high stakes, high profile case, and you know, I don't think they were impressed by. I wasn't thinking about the law of contempt, which is what sort of fell out in the course of the trial from Mr. Ann. So I do think that there are some aspects of it which are particular. But you can imagine that there would be some circumstances in which someone protesting the innocence of someone, particularly if they're sort of high profile, and I mean, we do have instances from time to time where people sort of dip their oar into sort of, you know, public controversies and things like that in a way where they don't have a sort of particular relationship to, you know, the people who are involved. So I think it may still have some work to do. I mean, anything that reflects on someone's guilt is much more dangerous territory, but I don't think innocence is, I wouldn't say sort of categorically it's not.
Damn it.
You could always say that. I mean, in most instances, it's consistent with the presumption. I mean, if the way in which you're doing it is, you know, well, of course that person's innocent and we have to proceed on that basis because of the presumption of innocence, then, you know, the risk must be lower about statements of innocence. But yeah, I mean, Ran also tried to sort of make that distinction between you know, I have a deep conviction that he's innocent and saying that he's innocent. And it's like that's a distinction without a difference. So, I mean, there are particular sort of aspects, I think, to the way in which that case was sort of conducted, which led to the very substantial punishment at the end. Because I wasn't that Daily Mirror was fined $200,000 in 1986-87 coin, which could have bought a house in Sydney. Time.
Let's take a question from online.
We have 3 questions, so
Okay.
I'll start with the first one. It relates to the discussion about extraterritoriality.
Easy stuff.
Is there a need for cooperation between the states in the federal context?
I don't think it would make that much of a difference, would it? Because you'd still have to try and enforce it. Oh, you mean extraterritorial? Well, no, but if it's extraterritorial and it's going to be overseas, I don't think it would make that much of a difference. Because you still have the enforceability issue, because it's the comity considerations in private international law which would apply. So whether or not it's I don't know what your view is.
Well, yeah, I mean, I suppose there's a difference between contempt and, you know, a suppression order, because obviously, you know, the model legislation for suppression and non-publication orders considers extraterritorial operation or the ability of an order to operate throughout Australia. So I suppose contempt as a body of common law principle would probably be in a different position from the, I mean, not every jurisdiction has obviously adopted the model legislation, but would probably be in a different position from the court suppression and non-publication orders legislation. I mean, to the extent that there is any sort of consideration of these sorts of things, I think courts tend to sort of minimise or avoid them. So you saw in Pell the sort of the extraterritorial contempts fall away. You've had that decision about the Magistrates Court in Victoria, where there were publications in the Daily Telegraph and the Courier Mail that contravened a suppression order from the Magistrates Court. And the legislation in the Magistrates Court Act was construed by the Supreme Court of Victoria as not having extraterritorial operation. And then there was a sort of squibbing, I think, of whether the conduct of publication in Sydney and Brisbane was, was publication in Sydney or Brisbane, even though there were people in Victoria who could read that online, those newspapers online. I think the problem that we've got is that we just haven't really yet engaged with those issues of extraterritoriality because they're fiendishly sort of difficult, and statute gives rise to specific considerations about the construction of the statute and whether it has an extraterritorial operation. Whereas, I mean, I drafted some notes for the extraterritorial operation of contempt as a body of common law principle, but it was too hard. So I thought I'd leave it to the second edition. And so hopefully I might sort of...
The second edition being called Beyond Contempt.
Beyond Contempt.
We have two more questions online. One is short, one is long.
Okay.
What would your preference be?
Take the short one.
So the second question relates to the form of a contempt charge. What do you recommend by way of changes?
To the form of a contempt charge. Well,
The form of a contempt. It's a little unclear in the syntax. But a second question is the form of the contempt charge.
well, I mean, the rules in most jurisdictions will prescribe that you have to formulate a charge. And Coward and Stapleton, the High Court decision, which is the sort of leading authority on this, tells us that you have to convey enough to the person that they understand the gist of what's being put against them. So a lot of the sort of pleading rule requirements for criminal charges don't apply to contempt because it's not really a criminal charge. So duplicity doesn't apply to charging someone with contempt. So the person needs to understand, with sufficient particularity what it is that they've done, which is said to interfere with the administration of justice.
I think from a practical perspective, when I've had to draft charges, I tend to bring to it the mind of drafting with the precision of an indictment, because you have to have that level of precision, mainly because for all the usual pleading rules, you have to, as David rightly says, with respect, you have to communicate your grievance with sufficient particularity, so that they know what charge they have to meet. But that's always been the case, isn't it? I would have thought there's no sort of change that's required necessarily from that perspective.
I wouldn't have thought so.
What was the other question whilst we were online?
A little bit longer. So it's got a statement and there's some questions. The law of contempt is all but dead in New South Wales. No one should mourn its passing. The jury properly instructed will know to disregard external source information and focus on what they hear in court. There has been no major case involving a media organisation in this state this century. Yet this is not the approach taken in Victoria, where judges and prosecutors love nothing better than jailing journalists or threatening journalists with jail for the slightest of slights.
We told the Daily Mail not to email us.
This is very Q&A.
For the different aspects of the law in Victoria, the jury members less is that general contempt helps the judiciary and journalists.
I think I know who this is from.
Well, I mean, thank you for your question. We're doing a proper sort of Q&A type of response. I mean, doesn't it go back to sort of prosecutorial discretion? I mean, so obviously there's a different attitude taken in New South Wales by, judges and the Attorney General that they're going to sort of let a lot of this slide, whereas judges and the relevant prosecuting authorities in Victoria take a different view about that. I mean, I mean, my own view is that, you know, it's very difficult to say globally either that jurors will always do the right thing or jurors will never do the right thing. I think either of those sort of binaries are obviously wrong. But you have to proceed, as Justice McHugh sort of has said on more than one occasion in his judgments, the system proceeds on the basis that jurors will abide by directions that they're given. And, you know, if we take the view that that's not the case, then obviously we have to revisit the whole system of trial by jury. And so I think that that's something that has to weigh into whether the Attorney General, the Director of Public Prosecutions, or courts of their own motion will actually sort of set in motion prosecutions for contempt. And I think obviously the experience in New South Wales is that, you know, there's not a view that resources should be deployed for dealing with contempt.
And also, from a practical level, every time we go to court to resist a suppression order on the basis that a juror is going to be imperiled somehow off the back of a contemptuous publication, courts, certainly the higher courts, generally err on the side of caution, and they will always come down on the view, especially from the Court of Criminal Appeal in 3 recent instances, have said that that's what jurors do. They will abide by the directions. They are robust, and if they don't adhere to these principles, then what's the point of having jury trials, as you say?
I mean, the broader sort of point about the law of contempt being dead is, I think, you know, overstatement, because the Hernan Street obligation seems to me to be in rude health and generating a lot of contempt litigation, for which I'm very happy.
Yes.
Second edition is very happy.
We have further questions. Legislation leading to more contempt prosecutions, similar to the Open Courts Act, leading to more suppression orders. The applications are on weak grounds, solving a problem that doesn't exist.
Well, I mean, it'd be interesting. So there's some, I think, evidence that putting suppression orders on a legislative footing has led to an increase in the number of orders. But I'm not necessarily sure that that's been the experience necessarily in New South Wales.
I think there's been an increase. I think there's been an increase. I know Gina would have a view on this, because I know she keeps track of all
not in
the
the
suppression
same way
orders.
as Victoria.
Numbers of non-publication orders in New South Wales are very difficult to say are accurately being reported, because the only way to get them from the magistrate's court is if there's journalists in the room, is there to actually get the order, or they're making active inquiries with the media officer to determine them. I'd say we get about maybe half district courts, although I hasten to add they've recently kind of reviewed their processes and they are more actively pushing them out now. So I'd say really it's only the Supreme Court that we would get even close to accurate figures for. And I'm not even sure about that, because I've seen a spreadsheet recently of the ones that apparently were made in 2023, and I'm pretty sure I don't have that many in my little system. So.
From an anecdotal position, I think I've seen an increase in orders in New South Wales in particular. Not as much as perhaps Victoria, but...
No, well, I mean, the question then is really a question of legal culture then, isn't it? Because the experience in the UK and New Zealand has not been that putting contempt on a legislative footing has led to a proliferation of prosecutions for contempt. So the question then becomes, or reduces, I think, to a question of legal culture. What do people do in response to legislation? And if that raises consciousness and then people are invoking things that they're unaware of, that is interesting. But the experience in the UK and New Zealand, I don't think has sort of suggested that there's been a sort of outbreak of contempt prosecutions by putting it on a legislative footing.
But the position might be different here because of
legal culture.
Because of legal culture. It's a nice way of putting it. Does anyone else have any other questions from the audience? Surely somebody has a question. Ali.
Is the suggestion that the nature of publication for contempt and defamation is different, in the sense that the act of upload is the key point for contempt, whereas it's that bilateral act that is relevant for defamation? Do you see that as relevant to this extraterritorial question? Because it may actually make it harder to reach outside this jurisdiction if the upload takes place overseas.
Yes, and I think that's a potential problem. I mean, there are aspects of the Victorian Court of Appeal's decision in Mockbell on that sort of point, which I think are slightly problematic. The idea that, you know, it's upload and just simply putting that up there and making it available and not having to prove that anyone has sort of looked at it is sufficient to establish publication, which I think insufficiently takes into account the fact that in order for there to be a sub judice contempt, there needs to be a substantial risk of serious interference with the administration of justice. And I'm not sure that the judgment really grapples with the issue, which I would have thought is central to this. If no one's downloaded it, if no one's looked at it, how do you satisfy yourself that there's a substantial risk of serious interference with the administration of justice? And so I always thought reading that, well, you know, you would need to prove that someone looked at it. And in fact, you know, one person would probably be not sufficient for that purpose. So, I mean, the law on the concept of publication in contempt, I think, is not yet really sufficiently developed. I think I traversed the sort of 3 judgments that sort of touch on that. And I just think that, and one of them I think is Ibrahim, which is a suppression order case. And then you've got the Hinch contempt proceedings over the Adrian Bailey trial. I think the concept of publication in the context of contempt is underdeveloped at the moment. And I think that criticisms can be made of the reasoning in Mockbell. There are things that I think need to be teased out about that. So I think it'll be something that we'll have to revisit.
I suppose it could be quite interesting as well from like the experience in the UK when it comes to those cases. For example, the Ryan Giggs case immediately springs to mind, where there was an announcement in Parliament and then sort of Twitter lit up like a Christmas tree. Yeah. And so whilst there might not be any download necessarily in the jurisdiction, it might have been published internationally. It might have been picked up in the jurisdiction on social media, for example. And then if it does, in that like the Ryan Giggs sense, go viral, then that's a different kettle of fish altogether. But it's something that's trivial. I think wouldn't be a substantial interference with the administration of justice. Ladies and gentlemen, thank you very much for coming tonight. We've gone over time, as inevitably was going to be the case. David, thank you very much for agreeing to come and do this this evening.
Thank you.
As ever, it's been enlightening, and thank you very much for everyone for coming. And please go out to buy Contempt, David Rolph in all good bookshops at your local bookshop. Thank you very much, ladies and gentlemen.